Okay, so we're going to continue with the cases in part 2. And the next case is State versus Home on page 188. And this is illustrating that you can only marry one person at a time, and it's about a criminal bigamy statute. So one thing that's important in this particular case is that it took place in Utah. And Utah has some different laws about bigamy because of its history of polygamy. There's a constitutional provision against it. And the bigamy statute is what's important in this case. This is definitely one of those times where the specific words in the statute matter. So we have a polygamy issue, and if you've seen Sister Wives, this is exactly the same situation, factually speaking, as what that particular family situation was. We have one husband and we have multiple wives. The first wife is the civil wife, is the one that they're legally married to. The remaining wives are wives that had a religious ceremony with the husband but did not have any civil paperwork filed. So the first one would be the legal wife, and the remaining wives would be religious wives. And that ran afoul of the Utah bigamy statute. It would not necessarily run afoul of statutes in other states, because in other states, marriage is just defined for purposes of bigamy as civil marriage, as legal marriage. Well, that's not what the statute said in Utah. And the specific statutory provision at issue was that the Utah bigamy statute made it illegal to, when knowing you are married or the other person is married, purport to marry another person or cohabit with another person. That's really pretty broad. It didn't say holds themselves out to be married. It says cohabits with another person. And so the court went into a little bit about the fact that, well, these people were cohabiting because they did have marriage-like relationships. They had homes, they had children together, not unlike what was at issue in the Cody Brown case in Sister Wives. If you have seen that show at all, you might remember that there were 4 houses, one for each wife, and Cody would spend a night at each house. And so the wives didn't cohabit together, but Cody would go from house to house. And they really operated like a large family would. And the wives took care of each other's children, planned dinners together, that sort of thing. And so the Utah statute was really designed to get at that. This was a 2006 case. Now, your book goes into detail that this kind of changed in 2013. And in 2013, I remember when that was going on because I was watching Sister Wives at the time. And Cody Brown, the guy, the patriarch in Sister Wives, fought the Utah statute, and he was not successful in time. And so the whole family ended up moving to Nevada, where the laws did not prohibit their family situation. But this case is it's not been overturned, but the law has changed, and we'll talk about that in a second. So, but part of what was going on in 2013 with the Cody Brown case was that this statute was so broad that a married person can't cohabit with anyone else. So if you've got like a college dorm where you happen to have a young couple who are married, not dorm, but like a house where kids in college are living, or let's say law school. Let's say you're in law school and you're all from out of state and you all share a house together and 2 of you are married and the rest of your people who live in the house are housemates. That's cohabitation, and therefore felony bigamy under a Utah statute. So there were arguments made in 2013 that this is so broad that it doesn't even really talk about the nature of a family, or the situation of bigamy that it was designed, polygamy that it was designed to outlaw. But going into the case itself, Holm here, Rodney Holm, did not dispute the facts. He absolutely had family relationships with all of the wives. It wasn't a factual situation at all, but he said the bigamy statute is constitutionally defective on 2 grounds. The first ground being the free exercise of religion. And if you remember from constitutional law, there are 2 clauses to the freedom of religion. One is the Establishment Clause. The government cannot establish a state religion. The second is the free exercise clause, and that's what he's fighting under in the case. Is he's saying that this statute impermissibly abridges my freedom of religion. And the court said, we can do that. There are plenty of circumstances you might remember from constitutional law where our constitutional rights can be impinged upon. No, not all speech is constitutionally protected. I can't yell fire in a crowded theater. Not all guns and not all people possessing guns are protected by the Second Amendment. There's lots of situations where the court can impact our constitutional freedoms, and the court said another decision has already been made in that vein. No, that argument fails. But what I find interesting is the second argument, and that's the argument on due process. So the court uses, the petitioner used the case of Lawrence versus Texas. You may remember that. It's a very interesting case. I teach it every year when I teach my 101 paralegal students. The excerpt they get in their text is really small. So I go into detail into the entire case because the excerpt doesn't talk about the facts, and the facts are fascinating in Lawrence versus Texas. Lawrence versus Texas is a case that involves the right to privacy in one's own home when there is a same-sex relationship. And in Lawrence versus Texas, if you aren't familiar with the case itself, involved a love triangle with 3 men. And at the time, consensual sodomy was illegal, even among consenting adults behind closed doors in the state of Texas. It wasn't often enforced, and there were some states at the time that made all consensual sodomy illegal, even between heterosexual couples. In this particular case, love triangle between 3 men. 2 of them are alone inside one of their houses, and the third man realizes this and is jealous and made a false police report that he heard shots fired coming out of the residence. And so the police went in without a warrant, which they were entitled to do because it was an exigent circumstance, and shots fired, maybe someone's hurting, and found the 2 men engaged in consensual adult sodomy behind closed doors. And so they were charged with felony sodomy and then litigated all the way up to the Supreme Court, where the Supreme Court said, no, we have the constitutional right to privacy in that situation. Now, I find it very interesting that a polygamist sect would use a case involving homosexual relationships to say, we have the constitutional right to do this. But they did. And it kind of makes sense. He's saying, we have the privacy right to do whatever we want behind closed doors. And that makes a whole lot of sense if you think about it. The court really, really got specific about Lawrence versus Texas and said, nope, that's specific to gay and lesbian couples, which maybe I never saw it that way. I mean, I really saw it as a privacy case about consenting adults, because I do think it would protect certain actions involving multiple people that were not necessarily marriage. So people who are polyamorous, I think Lawrence protects that. According to this argument, not so much. It's just gay couples. So I find that really fascinating that that's the way this particular court viewed it. But the court said, Lawrence does not prevent our legislature from prohibiting polygamous behavior. And even though the statute itself was not specific to a marriage-like relationship, it included cohabitation. The court said it's perfectly fine. So the update relative, and there's a long dissent if you want to take a look at it, and the dissent is fairly well-founded, but in 2013, the Sister Wives family finally had their day in court challenging the challenging the bigamy statute again on basically the same grounds, that it was that it violates freedom of religion and substantive due process, the exact same arguments that were made in the case at bar, the one that we're talking about. Well, Obergefell was about that same time, and previous to 2013, Obergefell was a little bit after that, but there were some other cases involving gay marriage, Prop 13 and DOMA, and those were around the same time. And the court in Cody Brown's case, based on very similar facts and very similar arguments, the court had said initially the trial court agreed with Cody Brown and said this is not narrowly tailored enough. It violates your constitutional rights. We don't need to protect girls and women from coercion. That was part of the government's argument there, and to prevent fraud. And that makes sense. I don't think in either of these cases there was any inclination that there was fraud. There's no fraud at all. Or that the girls and women are coerced. If you've ever watched Sister Wives, I mean, it's not my cup of tea, but the women are fairly straightforward. They have businesses, they have stuff they do, and it doesn't seem like they're under Cody's thumb. That I don't know that was a significant factor in either one of the cases, but the court said that's not enough. And then it was appealed and became moot because the prosecution there announced that they would no longer be prosecuting it. I don't know how that's moot, since a new prosecutor could decide differently. So I don't find that completely moot, but that's what the court ruled. And yeah. So my question to you is do you think that the court would look at it today in 2020 and say it is a restriction on the freedom of religion? Now let's apply that to a polyamorous marriage or situation. So you've got people who are living in polyamory. Let's take one woman married to a man, and she has there's a boyfriend that they all live together. They can't claim a religious exemption. They're not religious, they're polyamorous. They have relationships with multiple people at the same time. They want to live together. Do you think that a court is going to allow that situation in the case of a bigamy statute that prohibits it, or if a statute should get passed prohibiting it? I think that's honestly the next avenue of litigation that we're going to see coming up, especially after the case involving Cody Brown, who ultimately was sort of justified in what he argued. So it's always interesting when reality TV becomes real life. It becomes real law, rather. All right, so we've got, I think, one more here. And that's the duty to support on page 64. And I think that's the last case in this section, and that's where this video will end. All right, so this duty of support is a short case. It's an interesting case from 1953. It is not a divorce case. It is a wife suing her husband for not keeping her to the status in which she would like to be accustomed. It's an odd case because it was 1953. It probably wouldn't happen this way today. And so you might be asking yourself, well, why would a person sue their spouse for support when they're not getting divorced? It was 1953. And if she divorced him, she would not be able to work on her own. In fact, it's an interesting case because, all right, the facts are fairly sad. So it was a second marriage for them. They didn't have any children, but by the time they went to trial, wife was 66, husband was 80. They'd been married, I think, 33 years. She testified she'd been a dutiful and obedient wife. And she testified, here are all these things that I have asked for and I've not gotten. He doesn't buy me clothes. He stopped letting me buy food. He buys it, or he provides a check and I go get it, but that's it. She did have some property, like some acreage, I think, left by her husband, and she had $1,500 in a savings account, and that's it. And she was saying that she's not being supported well enough by her husband. Why not just get divorced? Well, in 1953, she didn't really have. She was 66 years old in 1953. What was she going to do? She's not going to get an OnlyFans account. She's not going to, make videos and become an Instagrammer influencer and be able to. They shouldn't have any of that back then. There was nothing, not even traditional jobs for her. It's sad the way the case talks about her particular circumstance, because it wasn't good. She had, the only new clothes she'd had in 4 years was a coat, 4 years previous. She was lucky that her daughter would buy her maybe a dress a year. She was earning money from some of the things she was doing on the farm, chickens, eggs, things like that. She wanted a toilet. They did not have indoor plumbing services, and it was 1953, so it wasn't that long ago. She wanted some new furniture, heat in the car. It's just not that much. So she's saying my husband is not supporting me enough because he's not allowing these things. Then we find out, this is where my blood boiled a little bit when I turned a page on page 66, we find out that he owns 398 acres of land, at the time worth about 90 grand. He had bank deposits, about 13,000, interest, real estate, $8,000 or $9,000 a year, savings bonds. He had it. And the court even talks about this. The court said he had a reputation for more than ordinary frugality of which the plaintiff was aware when she married him. So that's the court's 1953 way of saying he was cheap as hell, and she knew it when she married him. And the court essentially said, you got food, you've got a roof over your head, that's support. And the court had the audacity to say, look, she has resources. She has a little savings account. She's got some land her first husband. When you look at today's statutes, she would be entitled to half of everything, or under, most likely half of everything. And the court's looking at her measly little savings account and her butter and egg money and saying, well, she's fine. And I just found it very sad. But what the case says is that legal support is fairly minimal. It doesn't mean you get heat in the car. It means you have a roof over your head. It means you have food to eat, and you have some basic safety. If she wanted to rent the 80 acres left by her first husband, she could. And the court said that was enough. So what you should get out of that is the duty to support is really for sustenance. And there was another case listed in there where there was no divorce filed, but the wife was suing for more support. Again, previously she wouldn't have had any options. In fact, the court even talks about one of the things she wanted was to use his credit because she didn't have any. That might even have been at a time in a state where women weren't allowed to amass credit in their name. So this was a big issue back then that probably isn't an issue now, but what you should get out of it is that support is for sustenance and not a whole lot more than that. That's the last case from week 2. I'm going to see how this platform works and see if you can see and hear everything, and I'll add more probably tomorrow.